This video is part of a series intended to help citizens, members of the media, public officials, or anyone acting on their behalf to better understand Florida's exceedingly broad Public Records Act. These videos may be used by anyone and may be freely distributed without charge. I am not an attorney. I am not qualified, nor am I authorized to give legal advice to the public, so I don't. Any information provided by me in person, on video, or through fogwatch.org is readily available from the Florida First Amendment Foundation and the Florida Attorney General's Office of Open Government, as well as many other sources online. With remarkable consistency, the courts of Florida have routinely stricken down attempts by public officials to frustrate access to public records. In 1889, the Florida Supreme Court held that public officials are obliged to keep records of official business, and those records belong to the office and not the office holder. Whenever a written record of the transaction of a public officer is a convenient and appropriate mode of discharging the duties of his office, it is not only his right, but his duty to keep the written memorial, whether expressly required to do so or not, and when kept, it becomes a public document, a public record, belonging to the public office and not to the officer. In 1905, the Escambia County Clerk of Court, A.M. McMillan, decided to profit by charging for access to public records within his custody. The Florida Supreme Court held that no public official had any authority to charge for services that were his duty to perform. In 1913, a clerk of court refused to allow a requester to inspect records that had been filed with the clerk but not yet recorded. The Florida Supreme Court held that such records became public when the clerk took custody of the records and were, therefore, subject to inspection.
I'm down now, baby. Someday I will be free. I'm gonna treat everybody like they treated for me. Oh.
In 1934, M.S. Couch, the city manager of the city of Daytona Beach, refused to allow Herbert M. Davidson, the editor of a local newspaper, to review the city's financial records. Couch justified the denial of access on the basis that Davidson was not a citizen of Daytona Beach and not a taxpayer, that Davidson was not specific enough in his request, and Davidson's request was not sincere and was intended only to provoke Couch. The Florida Supreme Court held that Davidson's place of residence and status as a taxpayer were irrelevant, that his request need not be specific because there was no such requirement in the statutes, and it did not matter what the citizen intends to do with the information when he obtains it. He may, if he desires, disseminate the information among the people by means of the press and public address, pamphlets, or by the writing of a book by way of favorable or unfavorable criticism of the methods and practices of the people's servants in their positions of trust. It is a matter of history that famous writers in England and France notably, and perhaps in other countries, have been the means of effecting salutary reforms by their novelistic criticisms of abuses of public powers. In 1944, the town clerk of Surfside told local realtors they could inspect property records, but they were not permitted to make copies. The Florida Supreme Court held that the right to inspect in many cases would be valueless without the right to copy. It is the clerk's duty to make provision for citizens to inspect and copy records in such reasonable manner as will accommodate the citizens while safeguarding the records. The court did not stop there. It found that accepting the clerk's argument would make rubbish of the well-known trilogy of Abraham Lincoln, and in place of government of, for, and by the people, we would have government by petty autocrats.
I'm gonna treat everybody like they treated for me. Oh.